Right, welcome back. We're talking the amendments to the Labour Relations Act, and we've been discussing that here in Rosebank, just north of central Johannesburg, and we want to get your thoughts. We'll be getting your tweets shortly, but we've got an audience here as well, and we want to get to them now to get a sense of what their concerns are, and let's see what responses we're going to get. Let's start on table number 7, and where we'll find Gershon Musian.
Thank you, Peter. This question is directed at the Honourable Minister and the DG. I'm from the Forum for Immigration Practitioners of South Africa. We have looked at the amendments, and it emphasizes a lot of protection on fixed-term contract workers, especially foreigners. We've seen the Department of Labour, I'm not sure if the DG and the Minister is aware, that the department is implementing the Employment Services Act, which still has no regulations, and is advocating or imposing on employers to terminate contracts of foreign workers, even if they are permanent contracts. Is the Minister aware and the DG aware? That's the question.
Okay. Are you aware?
Yes, we are aware.
And so it's intentional?
Let me put it this way. If a foreigner comes to the country, or there's an application for a visa, or what then happens is that the Department of Labour, working with the Department of Home Affairs, we then do what we refer to as salary benchmarking and all that. And then we write a report to Home Affairs for them to make a decision. So once that decision has been made, let's say the person has been given a 5-year contract. Now, when that comes to an end, it's not an automatic extension of the contract. So what needs to happen is that there must be a fresh application from the employer. Now, what then means is that that position has to be advertised. That's in line with what the Home Affairs, the migration regulations are saying, and also in line with what the Public Employment Services Act is saying. So we are not, we have not broken any law here. All what we are implementing is exactly the procedure that has been outlined to the Department of Labour, and it has to happen that way. Now, it's up to the employers to be proactive and say, the contract is about to come to an end. What do I do? If you're going to wait and try and deal with this matter at the 11th hour, putting pressure to the Department of Labour to do things that are not in line with the way in which things are done, you're going to create unnecessary tension, which exists currently with that employers group. Let's work together. There are laws to be complied with in this country, and it's our responsibility as a Department of Labour to see to it that we make everybody comply with those laws.
All right, and you're happy that these amendments are not going to get in the way of making sure that highly skilled labour that we need is not going to be affected in terms of coming into the country?
Yes, I mean, we have even going back to the days of Askisa, you'll find that there was a need identified there for, the role to be played by foreign people who possess skills that we don't have in the country. So there's that appreciation, and that is why we have a process that is outlined that has to be followed. We're not saying that we don't need to import skills. We have to in areas where we don't have the requisite competences and requisite skills.
Okay. Frank, is it Dikotla? Table number 2. Yes, sir.
Thank you very much. My name is Frank Dikotla from Randwater. And my question is more of a legal nature, directed at the director of the CCMA. Does the new labor relations amendments apply retrospective to the employment contracts that were entered into before the 1st of January 2015?
Okay.
That's my question.
Thanks very much, Peter. And thanks for the question. The simple, a blunt answer is yes and no, because the issue is that there was a period given which is almost like a transitional period, and that's what I was talking about, the 3 months. So if one had a contract that was for 6 months and it started in September but it ends on the 31st of March, then that period would end on the 31st of March. But if you entered into a contract on the 1st of January and you were employed to do a specific role and that role was defined, but now it's been identified that it has to carry on, if it's still got specific requirements and it's going to end in a few weeks or 2 months after that, that would be okay. But if it's actually now seen as a permanent or more permanent role in the organization, then your contract would transfer from being with an employment agent to being with an employer. And that's basically how the situation would work.
Okay, all right. Table 8 will find Johan Bard. Table 8, yep.
Thank you, Chair. Coming from a labour-intensive sector, the clothing manufacturing sector in South Africa, we are acutely aware that our labour market and the debates with regard to our labour market has to be contextualised within the realities of global competitiveness. My concern is how should the enforcement of minimum standards, particularly insofar as employment conditions and wages, how should they properly respond to job creation and job creation potential where such jobs are either currently being held or could be created below the minimum levels? The real issue is, and the question we should ask ourselves is, do we serve the national interest of job creation and poverty alleviation when the only response to enforcement of minimum standards is to put people out of work?
Okay.
Well, it's a very difficult question, precisely because you would want to make sure that everybody has a job. And there's a saying that half a loaf is better than no bread. But the reality is, if the intention is to deal with the issue of poverty, you cannot do something that seems to perpetuate poverty. Now, we're talking about people who are working, getting a wages at the end of the month, but they're poor. Precisely because when we set wages, there are a number of things that we don't take into consideration. This person who's going to be earning below the minimum wage has to travel, has to get to work, and by the time the month ends, this person doesn't have money. So what government want to do is to make sure that at least people are able to survive. And in setting the minimum wages, it's an attempt by government to deal with the question of poverty. So anything below that minimum wage is against the law. We understand the issues relating to wanting to create jobs. If you go through the sectoral determination, for instance, for small business, there are a number of concessions that we have made in making sure that the small business environment thrives and they can create jobs. But you cannot go beyond that. Otherwise, if you do so, then you create some sort of a two-tie kind of a labor dispensation. And those workers will begin to say, why are we treated differently from the others? So you always try to strike that balance. It is a very delicate and very difficult balance to strike.
All right. Okay. So earlier on, I did fish around, and I know that there's an employer organisation. There's a gentleman on the table over there. Right. If you could just stand up, identify yourself, and I want to ask you from an employer point of view, because there's been this perception that's existed for some time that the labour legislation in South Africa is a headache, and it's onerous, and it's hard work, and this is really putting pressure on employers and not wanting to employ new people. Is that the feeling of the people that you represent, and also what your thoughts as employers of these amendments?
Thank you, Peter. My name is Kenneth. My surname is Snyders, and I am from the Consolidated Association of Employers of the Southern Region, CSA basically. Most of our membership are from the metal engineering industry, and unfortunately it is an industry that is going through a very difficult period at this time. The amendments itself, I don't believe that for us as an association is a game changer. We have been anticipating it for a while, and we certainly have no intention to resort to strategic planning sessions aimed at finding creative solutions to circumvent these amendments. I must, however, add, though, that for us as an association, we have two priorities at the moment, which is basically member retention and job retention before we can even begin to talk about job creation. Between 2010 and now, we have lost more than 400 member companies, not because these member companies migrated to other employer associations, but simply due to the fact that they had to shut down or close as a result of conditions within this particular sector. So therefore, I'm actually glad to hear that the newly appointed chairperson of Transnet announced that they've spent over 80 billion rand on the market demand strategy thus far. So going forward, one of our priorities is to forge formal relationships with groups such as Transnet in order to participate in the MDS strategy as a partner rather than as an association or supplier, so that we can begin to secure some of the benefits that will be flowing out of 1064, Project 1064, which is your 1,064 newly or new locos that are going to be built. And then through facilitation from Transnet, that as an association we begin to interact with the OEMs that were appointed by Transnet, namely Bombardier, GE, and I recently learned that China South and China North have combined their forces.
Let me jump in a little bit, because I want to focus our conversation a little bit on the legislation itself. As an employer, is it good or bad for employers?
I think as far as our association is concerned, we are definitely not opposed to it. We think it's good. We believe, in any case, that temporary employment was never ever going to be sustainable, and therefore we have never adopted an approach whereby we promote it amongst our membership, and we don't foresee a situation where we are going to assist any of our members who would come and knock on our doors and look for creative solutions to find ways to circumvent the legislation as it stands now.
All
Definitely
right.
not.
Okay, all right. So a happy voice from one association at least. We're going to take another quick break, and then when we come back, I'm going to put it to Minister and DG as well that this perception about labour legislation in South Africa being too onerous, too hardcore. Is that fair, and how do we compare with perhaps other parts of the world in terms of legislation? All of that coming up after this. Stay with us.